Your Lordships, as previously mentioned, I am Miss Gill, Junior Counsel representing the respondents, St Bashams. As introduced by my learned friend, I shall be addressing whether Mr Wacker has breached any of the Convention rights through his selected method of punishment towards Billy Bunter. My Lords, may I proceed with my first submission? As previously stated by my learned senior, St Bashams is a private authority and is therefore not obliged to act with the act compatibly with the European Convention of Human Rights. My Lordships, I wish to put it to the Court that Article 6 of the European Convention of Human Rights within the instant case has not been infringed. My Lordships, may I refer you to the case of R.V. Fernhill Manor School ex parte Brown, which was heard on the 22nd of May 1992 in the Queen's Bench Division and reported on page 159 of the Administrative Law Reports. My Lords, are you familiar with the facts of this case?
No, we can jump to the highlighted section.
Indeed. This can be located on tab 14, page 2 of your Lordship's bundle. Mr Justice Brooke established within his judgment that the relationship between private schools, those who attend them, and founded on the contract which is made between the school and the parents on behalf of the children attending it. He refers to the contract between the two parties in question and clearly states in terms regards to the exclusion as the heads reserved the right of requiring the removal of any pupil whose influence is found to be detrimental. My Lords, within the instant case, as the parents of the appellant have voluntarily enrolled him within St Basham's private school, they have clearly agreed to abide by the statutes of the school. The contract is a completely private contract and is not underpinned by statute. My Lordships, it's clearly stated within contractual agreement under the statutes of the school, Mr Wacker's decisions are final and not subject to any appeal. Therefore, expelling the appellant without an independent and impartial tribunal is within the discretion and therefore does not infringe Article 6. I submit to the Court that Article 10, freedom of expression, is clearly a qualified right and is therefore subject to restrictions.
Before we jump away from Article 6, in terms of the right to a fair trial, would you accept that the European Court would supersede that of the private contract of the school, and that Mr Wacker's powers seem somewhat arbitrary?
It could be argued as that, my Lord. However, I do believe that by signing a contract which clearly states that whatever the headmaster says is to be against no appeal, the appellant has a very limited case.
Even if that is an assault?
Within the instant case, an assault hasn't actually taken place yet.
Do you know whether
it's a posed threat?
Well, do you see so a threat? You would say that's not a crime. Threat to assault someone.
My lord, my lady, I cannot answer your posed question.
Try.
May I confer with my learned senior?
Yeah, sure.
My lady, after conferring with my learned senior, I have arrived at the decision that it is a crime.
Thank you very much. Move on.
May I continue?
Yes, please.
I submit to the Court that Article 10, freedom of expression, is clearly a qualified right and therefore subject to restrictions. My Lordships, may I refer to the words of Article 10, subsection 2? They read, exercise of these freedoms may be subject to such restrictions or penalties for the protection of the reputation or rights of others. My Lordships, this clearly sets out the circumstances by which Article 10 can be interfered with. Based on the facts of the instant case, my Lords, the article which was written by the appellant, published in the school's termly magazine, has had a direct impact upon the reputation of Mr Wacker and St Basham's private school, as the magazine will be available for both students and parents to access. Further, as established by my learned senior, that St Basham's is a commercial business, I would like to bring to your Lordship's attention that the statement made by the appellant about Mr Basham is in the instant case defamatory. My Lordships, may I now refer you to the case of Lingens and Austria, which was heard in the in 1986 in the European Court of Human Rights. My Lords, are you acquainted with the facts of this case?
Move on to the relevant points. You've been given the 2-minute warning.
Indeed. These can be located on tab 15, page 2 of your Lordship's bundle. They read, in the court's view, with careful distinction needs to be made between facts and value judgments. The existence of the facts can be demonstrated, whereas the truth of value in judgment is not susceptible of proof. Your Lordships, within the instant case, the allegations against Mr. Wacker saying that he enjoys caning boys in school, particularly the young ones, are degrading, inappropriate and of an unsupported opinion. They are merely value statements which is not recognised as truth. My Lordships, I put to the court that not only are the appellant's accents restricting him from using Article 10 as a defence, however, they are also in breach of the article itself, as it has insulted an authoritative figure in an unjustifiable and unreasonable manner. Further, my Lordships, it is necessary to consider that the appellant was expelled permanently as he conducted another personal attack upon Mr. Wacker by seeking legal advice upon his own accordance. My Lordships, as previously stated, Mr. Wacker has discretion under school statutes to show his disapproval to any student who does not act in accordance with the statute. In this case, as the appellant has been highly offensive and insubordinate towards Mr. Wacker, he has full power to impose any choice of punishment upon the appellant without breaching Article 3 of his human rights and therefore rendering the appellant's argument. As Billy has witnessed caning before, he is aware of the consequences of not abiding by school statutes which could essentially constitute as bylaws and therefore are binding upon all students. To further this, as established by my senior counsel before enrolling in St Basham's, the appellant's parents did sign a private contractual agreement on behalf of the appellant and therefore have advanced knowledge of the school statutes and the subject disciplinary measures any student is subject to. My Lordships, I'd like to refer you to the case of Republic of Ireland and the United Kingdom, heard in the European Court of Human Rights in 1978.
Your time's up, please be very swift. Are you going to refer to anything?
I'd like to...
You got 3 lines.
This clearly states that torture amounts to inhuman treatment causing very serious and cruel suffering. My Lordships, in the instant case, it is evident that 4 strokes of the cane will not constitute very serious and cruel suffering and therefore do not breach Article 3 of the appellant's human rights.
That, though. In front of the school, with a cane.
I'd like to further my argument by putting forward that in order to consider on the grounds of torture, the level of severity depends on the circumstances of the case, such as duration of the treatment and its physical or mental effects. My Lordships, the facts of the instant case dictate that the punishment which is yet to be imposed upon the appellant is one of which could be considered not to be endured for a long period of time, and thus therefore meaning it will not result in long-lasting or physical pain.
Would you say that was proportionate to what Mr. Bunter wrote?
I believe it could be considered proportionate, as it should have been stated in the statute that disciplinary measures were to be taken if students...
And you've accepted it's a crime?
Yeah. My Lord.
Should we get the prosecution in now then?
And there's no right, does he have any right whatsoever to administer the cane under the law of England and Wales?
No, not after the Education Act of 1996. However,
and can a private contract overrule that in any way?
I believe it can overrule that. As
I don't believe it can.
Okay, maybe not.
So anything else you want to add before we finish up?
No, my Lordships, that concludes my submission. If
Thank
I
you
have
very
no
much.
further assistance.
Thanks all of you. Fantastic.
Thank you.